that actually now our property rights have been taken not just by the legislature but by the courts. The Florida courts have defined away these property rights of ours, and that should be subject to takings analysis, just like a judicial act, so that these sort of judicial decrees are the same as legislative fiat in this regard, invoking the ideas which had been floating around in legal scholarship and in some Supreme Court justices' concurring opinions for years. This idea, however, had never been recognized, at least by a plurality or a majority of the Supreme Court, and so one of the major issues, and the one we'll be discussing on this panel, was whether this idea of judicial taking should be recognized as applicable under the 15th, 14th, et cetera, amendments. The court took cert. 8 justices participated. Justice Stevens was recused because he owns beachfront property in Florida, apparently. And so the 8 justices remaining agreed on one thing, which was that there was no taking in this case. Effectively, 8 justices said that the Florida courts had gotten it right on Florida law and that there weren't property rights at issue here. Therefore, there was no taking. But Justice Scalia, in a plurality opinion joined by 3 others, endorsed the idea of judicial takings and said that they might exist. They should be subject to the usual requirements that any other takings would be, even if taking is accomplished by courts as opposed to the legislature. Justice Kennedy entered a concurring opinion, which Justice Sotomayor joined, in which he said that the Due Process Clause, in both its procedural and substantive dimensions, should be the recourse here. That's where we should look for help from courts that have arguably taken private property. And Justice Breyer entered another concurring opinion, joined by Justice Ginsburg, in which he said, because there is no taking here, and we all agree on that, there's simply, we shouldn't even reach the question of whether judicial takings exist or should be recognized. And he said, we should leave that question, quote, for another day. He did not specify which day, but I'm confident that he meant February 4th, 2011, at Duke Law School with this panel, which I would like to turn things over to. I'll just briefly introduce them. We're going to proceed in alphabetical order, lacking any other guiding principle here. Beginning with Professor Nestor Davidson. He is an associate professor of law at the University of Colorado Law School, soon to join the faculty at Fordham. His scholarship and teaching address many property-related subjects, including property itself, fair housing, local government. He clerked for Judge Tatel on the D.C. Circuit and for Justice Souter on the U.S. Supreme Court, then practiced real estate and housing law, both with Latham and Watkins, and as special counsel, or as a variety of positions, rather, in HUD before rejoining the academy. Professor Richard Epstein is the Lawrence A. Tisch Professor of Law at NYU, Senior Lecturer at the University of Chicago, Bedford Senior Fellow at the Hoover Institution, and easily one of the most well-known and influential legal academics in the world. He's written genre-shaping texts on torts, employment discrimination, and government regulation, among many other subjects. Perhaps most relevant for today, he also literally wrote the book on takings. His 1985 book, Takings, Private Property, and the Power of Eminent Domain, is still in many ways the gold standard in the field. Ilya Somin is Associate Professor of Law at George Mason Law School, where his teaching and research interests, like the issue of takings itself, straddle property law, constitutional law, and political participation. Many of you may know him from his blogging on the Volokh conspiracy, where he is an astoundingly productive contributor and often blogs on topics related to and including takings. So I'll turn it over to Professor Davidson. They'll each speak for a few minutes, and then we'll open it for questions, so please have those queued up.
Thank you, Joseph, particularly for taking the burden of explaining this case and relieving the rest of us on the panel from doing it. And thank you, Rebecca and Lauren and Elizabeth and Hannah and the rest of the staff at the Constitutional Law Journal. This is a great topic, and I really appreciate the opportunity to participate. So, as I think today's discussion will attest, Stop the Beach renourishment is going to be a great source of puzzlement and intellectual fodder, as so often happens when the court from time to time weighs in on property issues, particularly when they split in the way that they did here. It's also a great name for a case, and I was trying to think of ways of playing off it. Stop the beach, I want to get off. Let the beach go along. So my point of departure in the paper I'm talking about today is really, and I think my perspective on takings in general, I think is slightly different from our other panelists, and I think we'll have some good Q&A where that will emerge. But there is always a perennial debate whenever the court weighs in on particularly takings questions. This happens when we had Nolan and Dolan and Lucas and Palazzolo and Kelo and Tahoe Sierra, and any time the court weighs in on a main issue in the world of takings, regulatory takings, or the standard for public use, we tend to get a fairly well-recognized back and forth afterwards. Some folks think that the court gets it right when the court defends property rights, and some people see a threat in the lack of flexibility that a vigorous takings doctrine in various ways might bring. And as I started to think about Stop the Beach, my own instincts tend to be a little bit more towards the side of the debate that privileges a bit more governmental flexibility to respond to the kinds of problems that tend to then spark takings claims. But I think there's something a little bit different, or at least it struck me that there's something a little bit different about Stop the Beach re-nourishment and about the particular issue of where the judiciary sits in this debate. So what struck me in reading particularly Justice Scalia's plurality and his critique of the concurrences from Justice Kennedy and Justice Breyer is that none of the arguments that Justice Scalia makes in his plurality for why the Fifth and 14th Amendment should apply when you have a judicial action are really limited to the question of the takings clause itself. So his argument, for those who've read the case, is largely a textual and structural argument. He argues that there's nothing in the text of the Fifth Amendment in particular that draws a distinction between various arms of the state when you're thinking about the individual rights at issue. And he argues that there's no independent federal constitutional principle that would suggest that you treat the judiciary differently, at least for purposes of judicial review, for this constitutional protection. So when I teach property, I teach the pretty well-known case from 1948 of Shelley against Kramer. And for those who aren't familiar with Shelley, it's a case that involved some racially restrictive covenants, one in St. Louis, one in Detroit. And the issue came up to the Supreme Court whether or not the judicial enforcement of these racially restrictive covenants violated the 14th Amendment's Equal Protection Clause. And in rereading Shelley after reading Stop the Beach, it's striking the parallelism between Chief Justice Vinson's opinion in Shelley and Justice Scalia's argument in Stop the Beach. So Shelley, as with Stop the Beach, makes a fairly straightforward textual argument. The text of the 14th Amendment talks about the state. There's no independent reason why we should draw a distinction between various state actors. The court makes clear in Shelley that were this merely a question of purely private enforcement, we wouldn't attribute the racial discrimination that was embodied in these racially restricted covenants to the state. But once you get to the court, and the court is enforcing these covenants, then the 14th Amendment applies. And like Justice Scalia in Stop the Beach, the argument in Shelley reads very simply, very straightforwardly. It seems hard to argue with. And when I teach Shelley, inevitably the question comes up, well, why doesn't this then eliminate the whole question of state action? Because you have any number of constitutional provisions that need to be enforced that are implicated, particularly in the arena of property, and certainly in contracts as well. I tend to teach Shelley at the end of a unit I do about common interest communities, and we still get cases. There was one recently in New Jersey where people raise constitutional concerns when private enforcement of private covenants, particularly, but also this comes up in the context of trespass and other areas, where judicial enforcement of those private agreements, private arrangements, raise constitutional interest. And Shelley has been largely limited to its facts. The court hadn't been willing to really move much beyond the very narrow holding of Shelley. But reading Shelley next to the Stop the Beach concurrence, it struck me how similar they were. And Shelley is often associated with a kind of realist perspective on property that emphasizes the role of the state, that emphasizes the centrality of the state in both defining and enforcing certain private arrangements. And no one would accuse Justice Scalia of being, at least in the property arena, a legal realist, but it is striking, and this is really what I argue in the paper, how similar the arguments are and how similar the conclusions are. And so I think among the many interesting, perhaps, ironies in this case is really that, that striking parallelism. So of course, just briefly, there are some grounds on which you might distinguish a case like Shelley from a case like Stop the Beach, or from the basic idea of judicial takings. You might say that perhaps there's some textual difference between the Fifth Amendment as incorporated by the 14th and the Equal Protection Clause. I don't see that argument. I think the state means the state, and the argument that gets played out, at least if you're going to take a textualist approach, seems to be the same. Similarly with the kind of structural principle that, again, Chief Justice Vincent in Shelley makes, and Justice Scalia in Stop the Beach makes. Perhaps you could say there's some difference between defining a property right, as the Florida Supreme Court did in Stop the Beach, and enforcing a private agreement. But again, I think that's a distinction really without much difference. The one the argument that I've seen along these lines that makes the most sense to me is the one that I first saw with Leo Strahilovitz at Chicago, which is that perhaps what Justice Scalia means by judicial takings is there really is only a taking when the beneficiary of the judicial act is the state, right? So you could make an argument that we're really only dealing with a very narrow category of cases. We don't even really revisit the whole question of state action, because really the issue here is an arm of the state taking property for itself. And I think that there's a very good argument there. I just think at the end of the day, if you look at Justice Scalia's plurality, there's no, except for stray line here or there, there's really no thrust to his argument that really focuses at all on the beneficiary of the elimination of property rights. What he's focused on is the property holder themselves, right? So the question that Justice Scalia is focused on is whether or not there was an established property right, and whether or not a judicial decision has eliminated that established property right. And that's a scenario that could come up, and I think is most likely to come up in any kind of a private conflict. So you could imagine two neighbors and some new kind of novel proposition in, say, the law of nuisance. Say, go back to Clark against Moretti, you could imagine a sort of new regime of solar rights. I live in Boulder, Colorado. We have a very vigorous regime of solar rights. And in that context, at least on the text of Justice Scalia's plurality, you would still imagine very easily that a property right that was previously established has been eliminated, even though the beneficiary of that elimination is the neighbor, as opposed to, in my case, let's say the city of Boulder. And in general, I think, particularly in the context of regulatory takings, the court regularly melds together contexts in which the state is the beneficiary and contexts in which other private parties are the beneficiary. You can think of Loretto and the flooding cases and others where the question of whether or not there has been a taking arises, or Kilo for that matter, question arises in the context of state action that benefits another private party. So do I think that Stop the Beach renourishment, if we recognize the concept of a judicial taking, particularly in the way that Justice Scalia framed it, in the sort of straightforward textualist, this is the state is the state, and we can argue about the standard, and I have a section of my paper, we'll talk about it in the Q&A, about what the standard might be. We're not really quite sure yet, but do I think that if this is widely accepted, we're going to have a flood of, say, mall cases where people are asserting First Amendment interests, and we're suddenly back in the realm of a much broader view of when private action implicates the state? I'm not so sure, but if we were there, and this is really the sort of takeaway from the paper, I'm not sure that would necessarily be a bad thing. So for someone generally inclined to take a narrow view of the realm of takings, there may be a little bit of a silver lining if at least a case like this asks us to rethink that balance between private ordering and the role of the state. So I look forward to the Q&A, and I'm sure it'll be a lively discussion. So thank you.
Oh, yes. Sit on your hand. That was a very provocative presentation. I'm going to come at this from a slightly different fashion, and I guess at the outset I feel incumbent to be autobiographical. The first course that I ever studied in law school was in England, and it was Roman law. and including Roman law of property. After a while, I learned that as well. Constitutional law I regard as essentially a trivial add-on to some of the classical historical materials. And I think the Stop the Beach case is a perfect illustration of how it is you can spend your time talking about the sexy and alluring topic of judicial takings and then know nothing about the underlying problems associated with water law on which this thing starts to rest. And so what I want to do is to concentrate on how water law is formed, how it operates, how it applies to the state, and then in effect come up with the argument that we have a certain great irony here. In one of the few intelligent environmental law statutes that I ever encountered is the one place in which people seem to have genuine doubts about takings. Every one of the justices got the opinions wrong as far as I was concerned on the evaluation. So let me see if I can begin. The classic, in his opinion, Justice Scalia cites a bunch of early 19th century treatises about water law, which are incredibly learned and which go back to the English, American, and Roman practices on this subject. And there is a notion that all the law of water is governed by what is called the jus naturale, or the natural law. And this is a term which has fallen out of favor, of course, today. So the Roman law jus naturale references are carefully removed from Stop the Beach, as he cites something about the origins. But essentially what the jus naturale meant was that there are a set of practices that are so rational and so common that they have always been there, and that the function of the law is not to create these particular rights, but to recognize them. This is widely poo-pooed today, but in fact, if you're dealing in evolutionary perspective, the approach is almost certainly correct. That is, social institutions are created long before we have judges and benches and so forth. And what the natural law was a set of rules that was developed and widely accepted precisely because they managed to capture the essential features of the various institutions under regulation. Water, of course, is very different from land and is very erratic. And the body of water law that I want to talk about here, which was treated in Roman law, English law, and early American law as part of the jus naturale, was essentially the law of alluvion and the law of avulsion. And the term avulsion makes its way in backhanded fashion into Justice Scalia's opinion, where he doesn't know what it means. So the Romans start off with the following question. If you have a river, it's going to be dynamic. And if they start to move a little bit here and a little bit there, the law of alluvion says that the boundary line remains at the river with respect to all takers. And so somebody's land will expand an inch, somebody will contract an inch, and so forth. But the key point was that with these gradual movements, they're essentially random. Nobody on average is going to do better or worse than anybody else. And by making sure that you don't use your GPS system to locate the boundary, but use the river to do so, you will not get tiny slivers of land that will keep riparian from their essential set of riparian rights. And so this is a highly efficient system for trying to deal with these kinds of issues. Avulsion is a term which is used both in surgery on the one hand, I discovered, and in water law on the other, and it refers to a radical disjunction in which some external natural force comes along and completely moves the river. Now, these things could move a river hundreds of yards and so forth, and if you apply the alluvion situation, entire plots of land can change their ownership. So what the Romans did was technically correct and quite elegant. They said that the old river is no longer there are no riparians, and they divided the river base between the two people on the shore instead of leaving it open to first possession, so that you get an automatic seamless continuation of rights. And then where the river landed, what you did is you had a new river, new riparian rights, which were formed in exactly the same way, so that you managed to have an automatic set of legal responses that everybody could understand without having to have any political manipulation in order to establish and to work boundary lines. And the key feature, of course, was that avulsion had to be by a natural event, because if you did have something like a deliberate diversion of a river, this would be a source of huge dislocation. Somebody dams up a river and pushes it off in another direction. So whether you're dealing with prior appropriation systems or with natural laws, natural flow systems, or anything else, essentially you develop an absolutely ironclad distinction between those things that are wrought by nature, which you just simply let the chips fall where they may in the manner I've indicated, and those things which are wrought by the hand of man, to which you find every single sanction available in order to prevent these things from taking place. It would be a total catastrophe, and everybody understood it, if you could dam the headwaters and put it all into a barrel and starve out everybody on the downriver. Well, this is the way the natural law had been organized in virtually every place. And when the judges recognize that they're not creating anything, they're just simply following a pattern. So a judicial taking is where you shift away from this particular system by a judicial decision that doesn't understand what's going on. Perfectly sensible kind of notion, because you're not dealing with an artificial creation by a judge in one day, which you then get an artificial change the next day. You're dealing with a set of rights which are very powerful embodied property. Well, you come to Florida, and what happens is there's a case in the 1920s called Martin and Bush, in which what the state does is it drains a lake. And that meant that the littoral owners, that is the riparians on a lake are called littoral owners in some places, no longer have a lakefront property. And these geniuses on the Florida Supreme Court introduce a pattern of behavior which represents the single most reprehensible portion of American jurisprudence with water rights, which is that the state has some kind of a dominant easement so that they are not going to be bound by any of the traditional conventions that bind private parties. And the ultimate expression of this is the Willow River case, and there are a bunch of earlier cases in water law, all of which say that a navigation servitude in the federal government under the commerce power or in the state governments under their local police powers means that this elaborate interactive structure dealing with private property rights can be altered like that by a federal government with no compensation owing. If you go back and you look at the earlier treatises, since they were natural law type treatises, they always say you can do this, but if it's a taking for public use, and just compensation is going to be required. So that was the layout. Martin and Bush is clearly wrong in terms of the way in which it's done, and it's part of a long system of state aggregation. And if you look at what Nestor said, he in effect said you got to be worried about some of this stuff where the state is taking it with their own beneficiary. All of these cases show exactly this terrible type of characteristic. So then that case was not called an avulsion case. And when you get to the Stop the Beach case, what happens is you get a scheme which has several features to it. And let me go over again what they were, because I said this was an intelligent environmental scheme, which is almost an oxymoron. What they did, in effect, is they have a beach stabilization problem. And the first question you have to ask about stabilization is, why does this require collective action to begin with? Why can't I stabilize my part of the beach with a little wall and you stabilize yours? And the answer is because Mother Nature does not respect small boundaries. If you look at waterfront properties, they tend to be long and thin to maximize the number of people who have beachfront access. And if you try to just wall off one section of the thing, water will come around it and wreck you. So you have to get coordinated efforts. And so when they do that, you can only do it through coercive activities of the state. It's a public goods problem. What they did, however, is they said, look, we're doing three things at once. One is we're building out, and we're keeping that on the leeward side. So you're not going to have it. But, and I want to stress this, you will have an easement whereby you could walk over this land to get to the beach, and you will have an easement where we won't build anything on this land to obstruct your view. So if you're trying to figure out what the key elements of value are, both of them are being preserved by a system of easements that are given coterminous with the system of takings, and which prevent the use of the land by the government. In addition, you get the benefit of your land being stabilized. The correct analysis, if you're thinking about this as a takings law, is to ask whether the bundle of goodies that are coming back offset the burdens that are imposed on the other side. And you can make individual variations on this, of course, if you'd like, but generally speaking, looking at this, it doesn't seem to me like it's a particularly bad deal one way or another. I might remand and ask somebody whether or not there's a net decrement in value. My guess is there's not, unless you could find somebody else who's going to get from this, as you can with all the land use regulation cases. So I'm almost sure that this is a taking for which just compensation is going to be appropriate. What Justice Scalia does is he looks at Marshall, the Martin and Bush case, doesn't know anything about the underlying systems of property law. And so instead of treating that case as a renegade from justice, what he does is he treats it as setting the state baseline. And then what he says is, oh, since it turns out that that was an avulsion case, we've got an avulsion here. Well, there's only two things wrong with the argument. First is the first case was not treated as an avulsion case. The word is nowhere in the opinion. It's treated as a drainage case, which is a different sort of thing. And then the second case would not be an avulsion case because it involves conscious human manipulation, which was always excluded by every definition everywhere from the beginning of time. So what you do is you have a complete blunder in how the property rights stuff comes out. Then what he does is he gets the right result for the wrong reason. He says that since this is now evulsive property, it can owned by the state under the default route of Martin and Bush, which is again completely wrong. He ignores the two easements because that would make the case actually interesting. And under his view of the situation, he says, hey, they own the land. It would be okay if they got rid of both these easements because there is no taking after all, so we don't have to worry about the compensation. And if they wanted to build a high tower on this property and block the view, that would be perfectly okay with him. Well, this is lunacy. And he kind of knows that because he says this is counterintuitive. That's the word he uses. That's a polite word for saying, I really don't know what I'm talking about. I know I've managed to box myself into a terrible type situation when I've articulated the right in these fashions. Oh, by the way, I haven't taken into account the two easements, which actually may alter the case. So what he does is he gets the right result in this case for the wrong reason. Now, why does it matter is the question you have to ask yourself. Because if you read Justice Scalia's opinion, essentially what he has done is he basically has increased the scope of arbitrary government actions, just as they are arbitrary government actions in the navigation servitude context, where we can do anything no matter what the disruptions, and the compensation you get is totally zilch. If he had done it right and had figured out what was going on, the inquiry would no longer be, hey, there's nothing here that's gone on. The government owns everything and can do what it darn well pleases, which is what he comes up with in the end. It would be, yes, they've taken it, and yes, they've compensated it. And if, in fact, they altered this statute so that it would allow the state to block access and to block views, then, in effect, we know what the loss is and we know what the compensation kind is there. It's not there. You have to pay cash. So by doing this, essentially, he, in a kind of an ignorant fashion, manages to create a set of results which creates exactly the wrong kind of state discretion for exactly the wrong kinds of reasons. And what he had to do, and what all these guys had to do, is to actually sit down and look at the scheme, figure out what it was doing and how it played out, and understand something about the underlying system of water rights so that you don't bring into constitutional discourse a set of definitions which have no antecedent anywhere in the known civilized world and say that a state is free to adopt these definitions if they want. Well, we can now do all sorts of things. We can say, well, Duke owns this property, but we're going to redefine it so it means that it can only keep people out at midnight. Come the day, everybody in the public has a right to walk in and use it in whatever way they see fit. Well, you can't be that stipulative with less respect to property. And just to take something off what Nestor said, if you did this in effect with, other kinds of rights, people would start to strangle you. Oh, a woman's right to her own body, that's only true on Tuesdays and Thursdays, right? But the rest of the time it's not rape because it turns out she doesn't have the property right in her own person. I mean, just look at this. The state's got all sorts of wonderful flexibility in the way in which it defines property rights. And the thing to understand is this is not an opinion in which Justice Scalia, Justice Breyer, Justice Kennedy had some real agenda. They're actually struggling with some serious problems. The thing that's so extraordinary about it is how ill-equipped they are to deal with the issues that they talk about because they simply don't respect the private property tradition. So this gets me back to the first point. By virtue of not being a constitutional lawyer, you have an immense advantage in studying these kinds of relationships because you actually bother to care about the property scheme, how it's put together, and so forth. And the just compensation clause, if you keep all of its elements together, is in fact an incredibly precise summary of the way in which these complex public and private interactions ought to be organized. And what we've seen now is a recognition of a judicial takings doctrine which will be so limp, flaccid, ignorant, and ill-informed that it will be just another one of the sorry confusions in the long history of the United States' dreadful jurisprudence with respect to takings law. A total bunch of amateurs when it comes to dealing with this problem. Thank you.
I'd like to thank the Journal for organizing this symposium, and I'd also like to say, I have to admit right off the bat, that I'm one of these people that Richard was talking about that really knows nothing about the law of water rights and water property. I really only teach landlubber property rights. So therefore, I was very happy when I read Richard's paper, said, phew, I'm not going to have to deal with this set of issues. Instead, I'm going to talk about the problem of judicial takings and whether such a thing should actually exist, because even though it may not seem like it from this panel, there are actually lots of respectable people in the world who think there is no such thing as a judicial taking, that it's an oxymoron and doesn't make sense. And I'm going to contest that idea and suggest it actually does make good sense, and that judicial takings really should be treated just the same way as any other kind of takings. In my first part of my presentation, I'll talk about that in a general way, referring to the text and structure of the Constitution. And in the second, I'll talk about some practical problems that various people, such as Justice Breyer, have raised, saying, well, if we do recognize judicial takings, even if that's legally correct, terrible things will happen, huge amounts of litigation will occur, the courts will be clogged with this stuff, and I'm going to suggest that those sorts of fears are, at the very least, significantly overblown. So first, just sort of naively looking at the text of the Fifth Amendment, it says, nor shall private property be taken for public use without just compensation. That doesn't seem to distinguish, as Justice Scalia points out, between different agents of the state, whether they be judges, legislators, administrators, garbage collectors, and so on. If any of these state actors take private property without just compensation, they seem to all be covered by the text of the amendment. I think if you look at the original meaning of the amendment, you get a similar result. And if you look at how people talked about these things in the 18th century, it's true, of course, they didn't specifically discuss the issue of judicial takings, something that Scalia acknowledges and that Justice Kennedy points out. However, nowhere did they say that judges are somehow excluded from this, and given their overall way of thinking about this, it would be very surprising if they did, because they did not, unlike Justice Scalia, they did not, in fact, believe that property law is just solely the creation of the state. To the contrary, they believed the property law was a natural right that had a justification independent of the state, and that's why the state was not permitted to violate natural property rights in their view, because they're justified by nature, by external considerations. So from their point of view, whether it's a judicial actor that violates the rights as opposed to a legislator or some other official would not make any difference. And I think that's one reason why they use the general words rather than specify a particular kind of government entity. Now, I would note that this is not just purely an originalist argument, because if you look at other areas of the Bill of Rights, other areas of constitutional law, judicial actors also tend to generally be treated the same way as legislative or executive actors. Good example, New York Times versus Sullivan, a case that many of you, I think, have perhaps read in constitutional law. That was a case where there was a judicial ruling limiting speech based on a libel action where it was claimed that the New York Times had libeled a public figure, but the Supreme Court said, no, it doesn't matter that this is a court that is doing this. It's still an infringement on freedom of speech. And there are other cases along these lines that can be cited, but the basic idea is that this thought that judges can violate constitutional rights is not unique to Stop the Beach or to the property context. Now, nonetheless, there are some conceptual arguments that people have offered for why maybe judicial takings might be different from other judicial infringements in constitutional rights. One, suggested by Justice Kennedy in his concurring opinion in Stop the Beach, he says, well, if there's a taking, it requires compensation, but judges don't have the right to order compensation, and therefore, if they don't have the right to order compensation or to order these monetary payments, and they can't possibly be engaged in a taking. And I guess I think there's two problems with his argument. One is, even if there's maybe three, the one that Richard pointed out that it's stupid, I wouldn't go so far as to say stupid, I would merely say very badly misguided and misinformed. Yes, I am, only in comparison to Richard would people say that I'm genteel, but however, to get back to why the argument may be misguided or even stupid, I think the point is that if his argument is correct, this merely means that the judge's actions in these cases are illegal under state law. But the fact that they're violating state law does not mean that they can't also simultaneously be violating federal constitutional law. These are not two mutually exclusive categories. They can happen simultaneously. Second, there's no logical reason, at least as far as federal constitutional law is concerned, why a state could not, in fact, authorize its judges to engage in taking takings or to require compensation. And I guess third, as Justice Scalia points out, compensation is not in fact the exclusive remedy for a taking. There are other kinds of remedies that are available, such as simply reversing the offending regulatory action, and the Supreme Court has recognized this for a long time. So the argument is not a very compelling one. Second argument offered by, in a critique of Justice Scalia's opinion by John Echeverria, professor at Vermont Law School, is that, well, we are concerned about takings for the reason that takings, when they occur, might be a majoritarian abuse. That is, it might be a case where the majority wants to take away the property of some minority to use for their own benefit. But judges, he says, they're a counter-majoritarian institution. They're not democratically accountable. So we don't need to worry about judges engaging in majoritarian abuses. And I think there are two problems with this argument as well. One is that nothing in the text of the Fifth Amendment suggests that we're only supposed to worry about takings when the taking is supported by a majority, as opposed to when it's a narrow interest group that has lobbied for the taking, or simply a well-meaning but misguided group of government officials. The second is that it's a little too quick to assume that judges are immune from majoritarian pressure. In fact, there's a large literature that suggests that public opinion does influence judicial decision-making. That's obviously going to be true in states where the judiciary is elected, some Echeverria acknowledges, but even where the judiciary is appointed by a variety of mechanisms, public opinion has an impact. So the argument is wrong both in assuming that the Fifth Amendment protects only against majoritarian abuses and in assuming that judges don't engage in majoritarian abuses. Finally, there is the argument that recognizing judicial takings would unduly interfere with state judges' power to shape state property law. So if these are guys that shape the property law, then you can't come in and tell them, well, you did it wrong, or you owe compensation. The obvious problem here is that state legislatures also shape state property law. In fact, they have more power to do so than judges do because the state legislatures can override judicial decisions on common law property rights if they so choose. So if you take seriously this argument, then you wouldn't have legislative takings either. I would also note that with respect to both judges and legislatures, at least under the federal constitution, their power to shape the property law is not infinite. Rather, at least as an original matter, it's supposed to be limited by these natural rights principles that were virtually universally accepted by the founders. So let's say that you agree with me, as to some extent at least the other two panelists do, that there are judicial takings. Maybe nonetheless there are horrible practical problems. If you recognize this idea, maybe the sky really will fall. And there's a couple of issues that are raised along these lines. One is the fear, which I must admit was somewhat heightened by Richard's presentation, that judges actually, federal judges, they don't understand state property law. They don't know what they're doing. They're going to muck things up, destroy 2,000-year-old traditions of water rights, and so on. So the concern is, therefore, these federal judges shouldn't be involved in these things because they don't really understand state property law. I have... maybe the state judges don't understand it either, but the argument would be that state judges have a slightly lower level of ignorance than the federal judges do here. Now, this is an argument that I actually addressed in much greater detail in another forthcoming article of mine in the University of Chicago Legal Forum, because it's not limited to the judicial takings context. It's often deployed against federal judicial protection of property rights in general. And there's a couple problems with it. One is, if you take it seriously, it would sweep away federal judicial protection of numerous other constitutional rights as well, because there are many areas in constitutional law where local officials and judges are likely to know more about what's going on than federal judges. Good example, Fourth Amendment search and seizure law, right? Whether a search or a seizure is reasonable depends enormously on variation in local conditions. Surely your local state judges, and even more so your local state police officers, they know much more about what really would be a reasonable search in the Duke campus than some federal judge does. But nonetheless, we still have federal judicial protection of these these rights because we recognize that state officials have a variety of perverse incentives and interests, so they can't simply be left alone to do what they want, even if they do have somewhat greater expertise. And there's many other areas of constitutional rights where similar issues arise, and once again, nobody argues that that means that federal judges should do hands-off. It's only with property rights do you get this argument about expertise. Secondly, I would actually say that with respect to many property rights, perhaps not the ones in this case, with respect to many property rights, it's actually easier for federal judges to understand what's going on than with some of these other local issues, because under the common law, property rights, for the most part, is divided up into fairly standardized bundles with a relatively limited number of types of different estates. And as Richard has pointed out in one of his other articles, there's a lot of standardization that has arisen through the spread of common law treatises and the like. So while there certainly are local complexities in property rights, there are probably fewer than in many other areas that the judges deal with. I would also note along these lines that this issue does not apply just to judicial takings. It applies to legislative and regulatory takings as well. After all, if you're asking, did the legislature take a property right, you still, just as in Stop the Beach, have to ask, was there a property right to begin with for them to take, right? So there's no reason to believe that judicial takings are inherently, by their nature, more complex than other more traditional takings by the legislature, by the executive. You're still left with a question, was there a property right there to begin with? So in this case, in this case, you see that kind of an issue, but it will arise in other taking cases as well. Lastly, there is the danger of the terrible flood of litigation that might arise if you recognize judicial takings, something that's mentioned by Justice Breyer. He says, well, one reason why we shouldn't recognize a cause of action for judicial takings unless it's absolutely necessary is that if we do, all sorts of ordinary property litigation will result in judicial takings cases. The federal courts will be completely clogged up with this stuff. The sky will collapse or whatnot. And I think such claims are greatly exaggerated for a couple reasons. First, even if you prove that there is an existing property right that has been impaired in some way under current Supreme Court doctrine, that's nowhere near enough to prove that a taking has occurred. The Supreme Court currently only recognizes per se takings, that is, state action that are automatically classed as takings, if there has been a permanent physical occupation of the property, or if there is a 100% loss of all economic value of the land. Even if there is a 100% loss that's lasts for a long time, but not permanently, as in the Tahoe Sierra case, that's not sufficient according to the Supreme Court. Everything else is analyzed under the so-called Penn Central test, which I'm not going to describe in detail, but I think most scholars and other commentators agree that that test is extremely deferential. Therefore, before filing these sorts of judicial takings claims, as with other claims, the property owners have to ask themselves, is there a strong enough chance that I can win something to justify the expensive litigation, the time it's going to take, and so forth? In a wide range of these situations, the answer is going to be no. Now, I do acknowledge that there might be more litigation under a less deferential test for regulatory takings, and I, like Richard, do in fact favor having a less deferential test. In that event, there would be more litigation, but I think this would occur even if we didn't recognize judicial takings as a separate category, it occur with legislative takings as well. And it really occurs anytime when the courts begin to more aggressively protect the constitutional right that has been neglected for a long period of time. For instance, after Brown versus Board of Education, there was a tremendous increase in racial discrimination litigation claims that states had violated the guarantee of the Equal Protection Clause. And whether this is a good thing or not depends on whether it is in fact true that a constitutional right has been violated and has been neglected for a long period of time. If it is true, then we should welcome the additional litigation, because the additional litigation will force these states to respect their constitutional obligations obligations, and over time, the litigation wave will subside as states adjust their behavior, and they can even obviously adjust the behavior of state judges if necessary by passing legislation to restrict their activities. In this presentation, however, it is not my purpose to argue for a less deferential standard with respect to regulatory takings. I merely want to say that what the standard that should exist, whatever the correct standard is, it should apply in the same way to the judiciary as it applies to other government actors. And on that note, I'm happy to conclude, and I very much look forward to the questions and discussion. Thank you.
To the panel for a fabulous presentation. We'd love to have some questions. I'll lead off with one, which is more a question about how it is that we know a judicial taking when we see it.
Sure.
And I hesitate here to drag Justice Scalia back out because he's taken a little bit of a beating. But he also writes, in addition to his reading of property law, that there is no judicial taking where state courts simply, quote, clarify and elaborate property entitlements that already exist, close quote, as opposed to changing the established property rights. And understandably here, we have a what seems to be a very clear and well-established property right, but I can imagine there are other areas of property law, and I hesitate to say this, that maybe the Romans didn't. Nuisance law, adverse possession. That was something they probably did. There must be something they didn't, right?
Yeah,
Maybe
intellectual property.
Intellectual, right. So great. So say a state court slightly changes the law on intellectual. Is that also a taking? And is it the size of the change that matters, or is it how well established the original right was?
Look, I think that's a fair question, and let me see if I can answer it. I would answer it by going back to the distinction between alluvion and avulsion, and use this with respect to doctrine. If what you do is you have a system, for example, in which there are a large number of rules out there, and you make a perturbation, small in some sense, where at the time that you make it, you cannot be sure whether it's going to work in the favor of one side or another side. What happens is if you think the rule is an improvement, everybody shares it, and if you think that it's random in its incidence, you can't find a shift in wealth from one party to another. So to give you but one example, suppose what we do is we clarify the law of deeds and that we announce that parole evidence will not be admitted in circumstances A, B, or C, whereas before it had been done. Not a taking in my view, or more accurately, a fully compensated taking. Because what happens is you never know whether it's going to be the buyer or the seller who's going to be introducing this particular evidence. You're never going to know how much it's going to be. There are going to be other protections. So what you start to do is to look at the value of the property rights that everybody holds under title when they're not involved in litigation, and see if you could find any shift in wealth as a function of what's going on. I think the answer in virtually all of those cases is going to be no. And so the correct question is, we will assume that a forward-looking change of general orientation, which is non-biased in its orientation, essentially implies in-kind compensation so that we don't have to deal with it. You start looking at the avulsion cases, right? And before you were a riparian and now you're nothing with respect to this, you can't begin to make an argument that there's that kind of reciprocity with respect to favor. And so under those circumstances, it's not there. And it's amazing, by the way, how many of these judicial taking cases are in fact cases involving water rights where quite literally the fluidity of the situation, as it were, at the boundary lines make a great difference. So I refer in my paper to a case called Pash, and you know, is this a taking? There's an immemorial custom in Hawaii that if somebody is not developing his lands, other people may come on and take away the scrub brushes. And then the Hawaii Supreme Court says, we don't got that like that. We think it ought to be the other way, which is if there's somebody who's gathering scrublands, the owner cannot build. Right? Now, you can't think of that as an alluvion type situation. You've got to think of that as though it's an avulsion situation. The only difference is when you're dealing with collecting scrub bushes from Hawaiian plains, this cannot be a form of the jus naturale. Because it's dependent on various circumstances, so it has to be a custom. And as Blackstone said, whereas you're very receptive to natural law principles which don't require individual verification, you have to be deeply suspicious of claims of customary rights because they could be ad hoc trumped up situations. So the burdens of proof start to shift. And in the Pash case, when the Florida court did that, and it just completely reversed it, so the development rights were taken from their owners and given to somebody else, that's got to be a judicial taking. When they decide where the beach ends and they move it up from the mean high water mark to the scrub line, for example, that's also got to be a judicial taking one way or another. And what will happen is as follows. Nobody will sue abstractly on the incremental shaking unless they're involved in the case, right? And we could ignore that. So if you get the law right, those things won't give you anything. And what you'll do, in effect, if you have more aggression on the really conspicuous situation, it's not that there'll be more litigation after the fact that matters. There'll be less judicial, outrageous decisions to begin with. And the only problem is if the Supreme Court is as bad as is the state court, so that it is no better than the Hawaiian court on dealing with property rights, then this whole thing will fall apart. So if you want to assume universal ignorance, it doesn't matter what you do.
I don't know if you. So just a quick comment. I would say that how you recognize judicial taking is really exactly the same way as you recognize a taking by any other government body. That whatever standards you think are appropriate to apply to a legislature or to an administrative agency or to a government-controlled garbage collector or whatnot it would apply in this instance as well. And we can debate then whether the standards should be deferential or not. I think that's an important debate. But that's a different debate from whether a judiciary should be treated differently from other government actors. On a question of compensation, I think there's another interesting point in that it's got to be kept in mind that in most cases, the goal of litigation for the property owner is not merely to get a judge saying, well, you suffered a taking, but actually to get some cold, hard cash or other compensation. Or an injunction, yes, that would be, but an injunction would be of some value to the owner. So if you have like lots of sort of minor actions where either the owner has suffered very little loss or the amount of loss that he's suffered is smaller than the cost of litigating it would be, in practice, you're not likely to see those kinds of cases go into court because of the fact that even if the property owner wins, he or she is still actually going to lose because they will have had the expensive litigation but without any offsetting gain.
So the only thing I would add, I mean, I think that this dialogue makes clear that this is actually a really hard question. And I think if you have a very clear 2,000-year well-established tradition that everyone recognizes, or you have a principle, and Richard, you articulated very well, of essentially no net loss in economic value in a legal transition, then things get a little bit easier. But that's not how I think most courts approach these questions. And here you have the Florida Supreme Court and then 8 members of the United States Supreme Court. Maybe they all got it wrong, but they're still defining the question of what is a change in state law. And I think in the absence of a consensus around a simple, clear baseline, and I don't think we have that consensus, the question of which institution and at what level and with what level of deference gets to say that there has been an elimination of property rights, which is what I think distinguishes judicial takings from other areas of takings law, which, whether it's a per se or it's a Penn Central, you're probably going to lose as a property owner kind of test. You're asking a slightly different set of questions. And obviously we don't know how, were Justice Scalia's view to be accepted, how the lower courts would receive that. John Echeverria sees this, for example, as a per se, as the proposal for another per se category, right? And I think it's a per se category that gets close to what Richard is talking about. But I don't think that that's entirely clear yet.
But remember, my view was that this was a fully compensable taking, right?
That's a different issue.
But you have to understand, if you're trying to talk about the level of hysteria, and you only look at you have to look at the other side, and I sustain this statute on much more sensible grounds than he does, as he admits.
What you'll end up with then, obviously, are questions about, on remand, right? You end up with questions about whether there's a sufficiency of compensation, right?
But and you know what?
And that
you do.
I'm not saying that's the worst thing in the world, right?
Yeah, I mean, you do that with every kind of taking, whether it's legislative or judicial.
The offset in takings, essentially, one of the things that's wrong about the common understanding of takings law is we in the law school tend to teach the question, is a regulatory taking compensable? There is a vast branch of takings law in which the government really does take things, and the only questions are these valuation questions. So you want to put a power line across things, and all you spend your time dealing with, not all, is offsets. This is a disadvantage to you, there's an amenity, you do this stuff all the way up and down the line. We do it all the time. You could do it better or worse, and in fact, that's a highly professional bar, because they know they're dealing with valuation questions where there's no doubt as to the underlying validity of the underlying taking. And so that seems to me to be there. And Nestor, I'm just going to look at this case. You know, the interesting thing is the best line that Justice Scalia could have taken on this is, this lame-brain decision was made 80 years ago. Nobody has done anything to interfere with it, so it's a kind of a prescriptive right. You know, we all have to face those things because that's the argument makes Plessy and Ferguson a very good case come 1953. It's been around for 57 years. Well, I don't think in this particular case you'd really want to do this. And let me just sort of put one other point in. It is not widely known or remembered, but if you go look at the dreadful decision of Justice Brennan, which is enlightenment personified compared to the completely wacko opinion by Justice Breitel in the New York Court of Appeals, what case do you think he cites to support the idea that property rights are not simply mere economic interests? It is none other than Willow River, which is another one of those dreadful navigation servitude cases. So this is a case where the Willow River was a $4,000 claim. Nobody cares much about that one way or another. Penn Central's a multi-billion-dollar issue, and he mangled it beyond all recognition because he did not want to treat one of two ways you could have treated that case. You could have treated it as a rate of return case dealing with invested values in the underlying station. And what Justice Breitel below had done is says, all the value that you have is attributable to your neighbors, so we don't have to compensate you, which if that's the end of a property law as we know it if it's true. Or you could treat it as a confiscation of air rights. And no matter which way you do, both of those are per se takings rules for which the compensation question has to be answered. And they answered it in that case. They said, we have given you an adequate compensation, so therefore the case should be decided in favor of the government. That's what they said, right? Remember that? We give you air rights which are worthless in exchange for those that have great value. And since we've given you something greater than zero, we will presume that it is equal to the value of the thing that we've taken. We don't need to, as grown men and women, tolerate that kind of stuff from the justices of the United States Supreme Court or the New York Court of Appeal. That's what they said. And it's so mind-boggling ignorant. You don't know what to say about it. How could you say just compensation is inadequate compensation? There's synonyms. That's what he said.
Maybe we want to do additional questions against it.
Questions? Yeah.
Practical question. If they found this was a taking, who's going to pay for it? The court system?
Well, I mean, in this, no, the practical question in this particular case, given that it's gone on, well, first of all, if it's a taking, you have to go through all the offsets, right? And in my view is that they're probably, in this case, at 100% or better, so I don't think it would come up. But suppose it was another type of situation. No, I think that the answer is as follows. Either the legislature appropriates the money or you go back to the prior division of rights. What was so incredibly uninformed about Justice Kennedy's remarks is he assumed that if, in fact, you couldn't supply the compensation, you were free from the takings clause, where the correct answer is if you can't supply the compensation, you can't do the action. And so the budgetary issue just disappears if you grant an injunction. So you're right back to the previous boundary line. In this case, the solution would be that the guy could rip down the wall. But I guarantee you he wouldn't do it, right? Because his value of his property would go down.
So I recognize there's this concern, well, judges do a taking and the legislators and also the taxpayers will have to pay. I think that's not unique to the judicial taking situations. You often might have a situation where one government agency does something which, say, the legislature might not be happy about it if they knew about it in advance, or the executive might not be happy or whatnot. The problem is it's a kind of agency, right? That if your agents in the course of your of acting on your behalf commit wrongs, then you got to pay, and that's what the takings clause is about. If the legislature doesn't like it, they do have a remedy. They can pass statutes forbidding their state courts to do these sorts of things, right? Or if in the extreme, they could even pass things such as that the judge's salary will be docked if federal courts find that his rulings amount to judicial taking. So state legislatures do have ways of limiting their exposures, and I guess finally, as Richard suggested, not in all cases will monetary compensation even be the remedy. Sometimes it may be an injunction or something else.
But you got no problem conceptualizing the courts as the agents of the legislature.
The state government. The state government. The state government. Both the legislature and the courts are agents of the state government.
I'm going to tell you a case where I argued your side. One of the issues that came up in the Lucas case was the remedy that was ordered by the trial court judge after he found that there was a regulatory taking. He said, look, Regulatory takings are exactly the same as other kinds of takings. Since you've left him with no viable use, he required, in effect, the state to take title of the land from Mr. Lucas, required them to pay Mr. Lucas off, and then, in effect, he would use the money to pay off his mortgagees and go back to the rest. And so at this particular point, the state said, where the hell are we going to get $500,000 to pay off for this land now that we own it? And so they offered to sell the land to anybody who would buy it. Of course, nobody would buy it if you can't build on it except the neighbor, and he was willing to pay 60% of value for a side yard. And what it comes says, where are we going to get the other $200,000? And they couldn't find that either. So eventually what they did in this particular case is they sold it off to somebody who had the right to build the same house that Mr. Lucas had wanted to build in the first place, so that they all lived happily ever after. Now, this, of course, is in a form of mass insanity. As Lucas himself said dryly one day, he says, I think I could have found an easier way to sell my land to somebody else who wanted to buy it. I mean, you know, and he was clearly right about this, but I actually wrote in the brief, the amicus brief, I said, this is madness to essentially order that remedy. What you have to do to the state is to go say, look, you've done this thing. And now you have an option. It's been declared unconstitutional. You could go through with the purchase, or you could remove the regulation. And then you'd have to pay compensation for the interim loss. And at this point, there's a real foxy game that's going on, because the truth about the matter is, in many of these cases, people don't want to build at all, even though the land has building rights. And if they could come in and start to say, hey, the compensation should have been the amount that I would have gotten if I built it up, they're better off by virtue of being regulated and deregulated than if they had never been regulated at all. And so what you have to do is to check what's going on there. But in Lucas's case, that wasn't true. He actually had a plan to start to build one way or another. So once you get down into the situation, the key feature is that the revocation remedy, which we argued for quite explicitly, means that you don't force the state to go forward the way in which the trial judge in the Lucas case wanted to do, creating serious appropriations problem, which then resulted in the farcical situation. But we learned something about this. Bill, most of the stuff in favor of land use regulation is a classic instance of cheap talk. A bunch of guys talk about how important it is for them, the many benefits the community will get. They've got full taxing power, and the moment they add it is, what do we want to pay $500,000 for to keep a piece of land vacant, when if you built a house on it, we could get some tax revenues from? If you're not going to charge them, you're not going to hear that argument. The moment you charge them, you get honest public deliberation. And so I've always regarded the takings clause as an absolutely essential precondition for proper political deliberation. So I'm a communitarian. I have another. Is there another question?
I don't have that on tape, by the way.
It is on tape. It is on tape.
That's going out nationally.
We want it on tape.
I want to put on record that I am not a communitarian.
I'm a communitarian of a special sort. This was the argument, by the way, that Justice Scalia made in his dissent in Pinnell. You want to socialize everything through rent control? Be my guest. Just pay the landlord, and then you can do whatever you want with respect to the property, and the program just disappears. Because there's no... I wanted to disagree with Nestor. Question.
So I guess I should preface by saying I unfortunately haven't read this case, even though maybe I should have. It strikes me...
It's a real page turner.
All of Justice Scalia's opinions are.
I mean, on the judicial taking stuff, it's actually quite good.
It strikes me that there are multiple levels on which we can view the taking at issue, and one of them that I guess concerns me is the difference between when you take a right incident to property by saying, okay, we are taking your air rights here, and we're going to fly commercial airliners over them, and when we define a right that was maybe formerly recognized as incident to property out of existence. So
what's the difference?
Well, the difference that it suggests to me, and I guess this is why I kind of want to know what you all think about this, is that if we recognize that rights exist only insofar as the court system or the state grants them, which I take it...
That's the whole natural law theory, says
right.
The state comes not to create rights, but to protect.
But to protect them.
Not a bad way to start. We'll start with your person, and we'll define it out of existence.
Okay. It's a good start.
So you now no longer have a right to speak.
Let the man finish.
No, he has no right to speak. You define it out.
But so if we were to recognize that at least on some level, some of these rights are not natural rights, and that the state does have a role in granting them.
Copyrights.
For copyrights. If the state simply defines them out of existence, in order for that to be a taking, it seems like you would have to have some sort of overarching right or ownership interest in the continuation of your rights through time in order for that to be a taking.
Wrong.
Why am I wrong?
Well, because what happens is there are two kinds of rights. There are what they call allodial rights coming from the ground up, i.e. first possession, water rights, and so forth. And then there are rights given by government grant. And the correct view is if the government is given a grant, unless it reserves the right to revocation, its revocation is a taking of the property that is so given. So this is no different from a private party giving you the fee outright and then coming back the next day and saying, I've redefined the rights and moving back in, you get absolutely nothing. And so for the patent system, for example, it is perfectly okay for the government to say, going forward in futuro, every patent shall last no longer than 24 hours. But if they have a patent which has been out there which has 11 years left to run and they say you have only one more right on it, then it's a revocation of a past grant. And the reason you do this is going after the patent's been issued, the government's always a hero. If they could take it for nothing, they will take it. But if you ask them to create a system and get anybody to invent with a 24-hour window to recover $1 billion worth of cost, it's not going to happen. And so what you have to do is to recognize that when you're dealing with state grants, is what you're talking about, you have to reserve the Christian tradition. And the very tricky thing is whether or not they're implied reservation rights. And here there's only one right which is implied because it's not part of the grant, it's part of inherent state power. So you go back to a case called West Coast against Davidson, 1849. The state conveys a bridge. And it's a covenant or charter, and the question is whether the federal government or the state government, when it wants to retake the bridge, can do so given the absolute nature of the contracts clause. No state shall impair the obligation of contract. And what they said is, well, we're going to read the just compensation exception into the contracts clause so the state can take it back on the same terms it could take anybody's property because eminent domain is an inherent power of the sovereign conditional upon the use of the eminent domain power, i.e. just compensation. So the system works perfectly well with respect to both kinds of titles, but every time somebody says that you're going to define something out of existence, what you just read is they're using the word define because they don't want to face the burden of having to take things. And definition is never allowed in any area where we give serious scrutiny. Just go to the First Amendment. We now define all speech as defamatory if it criticizes the government, right? That solves your problems, doesn't it? It's a wonderful way. You and Mubarak could run a wonderful state together under these kinds of powers. So it's the single most dangerous fallacy in constitutional law is to assume that serious substantive problems should be solved by defining type things one way or another. I remember when Charles Fried raised that in connection with the Nolan case, I wanted to strangle the man because he'd done exactly the same thing which ought never to have been done. You can destroy entire systems of rights by giving somebody, anybody, the power of definition. Limited government, if you can't take, you can't define.
So just a very...
This is a modest point.
So just a very quick comment. So one is, as you suggested in the first part of your question, that in fact there are, I think, important property rights which are not simply defined by the state. And to my mind, the bad part of Justice Scalia's opinion is not so much where perhaps he mucks up some of the issues relating to water rights, but where he says the property rights exist only insofar as state law allows them to exist. I think that I understand that's the conventional modern view, but I think unless it's just purely rhetorical, I think it's pernicious, both pernicious and wrong. Second, even if the state does grant certain property rights, and of course I agree that it does, it doesn't follow that if you have the power to create a right, that means you have the power to take it away anytime you want once you've created it. This is a fallacy that is well recognized in other areas of constitutional law. For example, if you've created a public school system, the fact that you don't have to have a public school system at all doesn't mean that you can have a public school system that is racially discriminatory or otherwise violates various constitutional rights, because even though it's your own creation out of the state, there are constraints in what you can do with it, and the same thing with at least certain kinds of state-created property rights. That if you say that the state has absolute power over everything that it creates, then a wide range of very pernicious problems arise.
The whole doctrine of unconstitutional conditions is what he's talking about.
Yes.
You may have the power to select is oftentimes much greater than the power to do it on an all-or-nothing basis. And if you treat it as an intermediate case, and if you could do the two extremes, you could do the middle. When you're dealing with state monopolies, you'll always make a mistake.
So just one small point, which is not to defend a view that says that all of these rights are entirely contingent and malleable, and certainly I don't defend that view in the paper. I will just say there is something to recommend as at times incoherent as it is Kennedy's view on this, which is the question of when a change in law has upset settled expectations. When we have crossed that line, A, is a hard question in many instances. Sometimes it won't be, but often it will be a hard question. And there are tools that we have that we regularly deploy, short of saying that, again, the state has absolute power. I don't think anyone would defend that position, but to say how clear was the right, what kinds of expectations were built up on it, what are the limits of those expectations? And I think we don't have a great approach to that, but we muddle through in a way that, depending on your view of the relative risk of an absolutist view or relative risk of perhaps the inflexibility that view would bring, I'm not sure that muddling through is necessarily the worst thing.
There are no,
Really trying to balance.
muddling through and marginal cases are two different phenomena. There are always going to be close cases under any system, but it doesn't mean that the basic principles are incoherent. And Justice Kennedy's contribution to the law and the due process takings decision is really one of the great sumpits of modern time. And let me give you the illustration as to why. There is a case called Eastern Energy against Apfel, right?
Well.
And this is a case in which you have a classic natural law violation of retroactive liability on somebody to pay for funds for things that he didn't do, right? I mean, about as bad as you can get. And 4 justices of the Supreme Court say this is unconstitutional because it's a taking without compensation. Justice Kennedy goes through exactly the same arguments and says it's under the Due Process Clause. What's the effect of fractionating the base in all subsequent cases? Everybody comes along and says, well, there were only 4 people who believed in the takings analysis. 1 guy believes in the due process analysis. There's no clear holding in the case, and so therefore it's dead. And so what you do in effect is the entire history of our law is that the Due Process Clause and the Takings Clause became interlocked inextricably when we had in one of the railroad cases in the 1890s, the Chicago, Burlington, and Quincy Railroad, a statement by Justice Harlan. When I'm looking at rate regulation under state law, the words "without due process of law" to me connote without just compensation, is what he says. And so the 2 bodies of law tend to merge on that thing because this is before full incorporation, and this is the way in which the federal government could supervise rate making. Well, at that point, you should treat the bodies of law identical. Otherwise, what's going to happen is they're going to overlap imperfectly, and every case will fall in the gap between them. And so this is just a case of gratuitous complications with no discernible public benefit. As to reasonable expectations, he's wrong again. The term is not circular. If you understand, there's no time to go into it now, but this is a case in which if you understood how it is that you get cooperation between actors that don't have contracts with one another, reasonable expectations is the way in which we structure social interactions. It's a normative concept. It is not simply a description of the way in which people behave. Everybody behaves badly, and so therefore all reasonable expectations are that everybody should do the wrong thing. And it just breaks down all legal systems.
We're right up against our limit. Professor Young, last question.
So Nestor, I know as a good conservative, I'm supposed to hate Shelley and Kramer, but it's been a while, and I'm struggling
Oh, it's
to
a
remember
terrible
why.
decision.
And I think it would help if you could spin out a few of the implications. Where are the wild places you think this could take us that Justice Kennedy is going to hate if you take seriously the notion of state action that you're finding in the case?
Well, I mean, I think that the obvious quick line you get to is the whole notion of state action falls away, right? So you then, I mean, I think that as a threshold matter, then the real tricky question is what types of private arrangements that, I mean, most private interactions are going to be relatively innocuous from a constitutional perspective, right? But there will be many that could implicate constitutional rights if you interpose the state, right? And so, again, take Pruneyard, take cases that involve balancing the right to exclude with an assertion of a right of access based on free speech. And again, there is a perspective on this that would say the right of exclusion is absolute and any intrusion on that is not to be tolerated or should be compensated. But I think that there is another perspective on that which would say if you recognize that when you call the sheriff and you say I am removing the person wearing the t-shirt that I disagree with, the state is acting, then we get into a question of whether or not that is in fact something that should be recognized as a question of constitutional right. And look, you know, I think that you know, to pick up on Ilya's point, you know, the wild place that would take you would be there'd be a lot more litigation over the balance between traditional private property rights and the constitutional implications of enforcing those rights. I think that there are good arguments for limiting that, but I think at the same time, the felt necessity, at least in some contexts, of bringing those interests in means that at least there's an argument. And who knows what that world would look like? We're never willing to
So
go
if I
there.
can just follow up.
Yeah.
It seems like though you're assuming that the underlying substantive constitutional provisions deal with the state in precisely the same way. So the obligation to provide equal protection of the laws, as it falls on courts, might bear on enforcing things like restrictive covenants. But we might not say that the First Amendment imposes the same obligations on shopping mall owners.
Yeah, but
No, that's right. I'm not saying that the substantive rights look exactly the same, right?
But
and it might be much narrower in this context than so you have a common interest community that does sign regulations, right? We might have a very different view of the balance we're going to draw in that context and questions of voluntary entrance into that community. I mean, there's a whole host of different reasons why you might achieve a different substantive outcome, right? But what we have tended to do is not even get into that question, at least as a matter of federal constitutional law. We have said, look, we're going to draw, at least in recent years, we're going to draw a pretty hard line. You see this in sort of how clearly limited Shelley has been. You see this in the rejection of Marsh. You see a lot of contexts in which the question of what the right balance is, we never get to that. We just say no state action, and therefore we don't have to ask those questions, which I think are hard questions and really very context specific. And I think what's interesting about Stop the Beach, although Scalia doesn't talk about it in these terms, what struck me as interesting in reading Shelley against, next to the plurality is how the framework, the threshold framework, can we even ask the constitutional question here, right? Is so, there's so much parallelism between.
Yeah, but it's on a different point. The big mistake in Shelley is not about judicial action. It's they completely mangle the law and restraint of alienation. That is, they do not distinguish between private restrictions with retained interest in property, which have generally been valid, and public restraints that are imposed by the state, which ought to be subject to a different kind of constriction. So if you go back and you read the end of the opinion, that's Vincent, I think, who wrote this thing, when he starts to talk about why these things are improper, he gets it all wrong on the private law side. And the mistake is this: there is no such thing as state action. The words in the Constitution are state deny or deprive, right? And if those are narrower words than state action, I think it's fair to say, and it has to be respected. And the argument that one makes is that if you have a government official which is simply doing the bidding of a private individual, the basic bargain in a natural law situation is we will give up the private right of enforcement of our own property rights if the state will supply it in exchange. And so when the sheriff comes and removes somebody, that's simply an appropriate substitute for self-help. If the underlying rights are right, the mere fact that there's enforcement of them is always going to be forgiven as part of the general social contract. And so that's why the Pruneyard case should come out in effect, that I can throw this man off my own property, and you're telling me I can't throw him off the property, the compensation you have to give to me is enforcement. That's straight out of John Locke, right? Chapters 2 and 3.
So this has been a fantastic discussion, as we expected. I think we should justly compensate our panel.
We ended up without flooding.